The facts of this case are as follows. Investors were given purportedly negligent advice by West Bromwich Building Society and wished to bring claims for tort and statutory duty against them. The Investors' Compensation Scheme, or ICS, agreed to sue on their behalf, and the investors' rights to compensation were assigned to this organisation. The investors signed a contract with the ICS, with one clause excluding from assignment to the ICS any claim, open brackets, whether sounding in rescission for undue influence or otherwise, close brackets. These claims could only be brought by the investors themselves and not the ICS. West Bromwich had argued that the or otherwise in that clause meant that claims for damages had been excluded from assignment to the ICS, meaning that the ICS could not pursue claims for tort and statutory duty, as the investors had wanted the organisation to do. The House of Lords gave an alternative way of wording this clause, which it thought best matched what the parties actually meant when they drafted the contract, that the ICS had not been assigned any claim sounding in rescission, open brackets, whether for undue influence or otherwise. This meant that claims for damages had been assigned, so ICS could bring these claims against West Bromwich Building Society. It was only claims for rescission that had been excluded. The House of Lords also established a new way of interpreting contracts, one which would reflect the actual intentions of parties to a contract, even if the language that they used was faulty. This involves taking into account the background knowledge of the parties, and this background knowledge may actually enable one to conclude that the parties used the wrong language or syntax when writing the contract. Furthermore, if the natural meaning of a contract's language goes against business common sense, then the language must be made to yield to business common sense. Previously, English courts had just interpreted contracts according to their language. The position was that words were enough for interpretation to occur smoothly, as they best reflected the parties' intentions, but this case stated otherwise. In other words, language was not enough. So, this case established a trend towards contextual interpretation in English law, and this approach was upheld by subsequent cases. However, more recent cases in the past few years appear to have reversed this trend. For more on this case, please visit the link in the description, which will take you to our website. You'll also be able to find more case summaries there.